We'll address the counterclaim first. I think it's the easiest. We did have a prior ruling by a court of competent jurisdiction in a forum that was not ours, and that there was an arbitration clause. He didn't rely on that. Bottom line is, no matter which way you look at it, I think we need to dismiss the counterclaim. It's pretty clear. Okay, that's that. Now, as to the main complaint, I'm kind of leaning towards dismissing that as well, because I know he used, going on the radio, trying to solicit signatures in that fashion, but he never, in fact, gave any signatures to the defendant. But even if we want to say, okay, you think you collected 400, that's what you kind of have come up with, he has still kept, pursuant to the contract, $1,500 of the $3,000 that he gave him. To that extent, he has received what he contracted for. Now, whether or not he spent $1,500 on a radio campaign, he's not seeking reimbursement for that.
Well, his theory, as I understand it, the defendant prevented him from performing the contract.
But he couldn't have, yeah.
And he's basing that on a methodology that he had come up with, which is nowhere in the contract, about how to calculate the signatures that would be attributed to him. It came out to, if I get this ad and you get more than $275
then you
a
have
month,
to attribute those to me.
Then you have to attribute them to me. And there was the fault in the methodology. And it wasn't because of what the defendant did. It was because I think the methodology wasn't
the premise that you rely, yeah.
The
other thing is,
I understand the plaintiff's complaint. In that proceeding that the defendant previously brought trying to get money paid back, the plaintiff learned that there were actually additional signatures that he'd collected that the defendant didn't give him credit for. I think given the prior adjudication, when the prior court dismissed the defendant's claim, they were dismissing the defendant's notion that the plaintiff didn't do the work.
We don't have a judgment in the
He said, we do have the judgment, and the defendant said, the prior court said that he doesn't owe you any money. So that means there are findings in that prior court judgment that I think don't require me to force this plaintiff to
I'll join Judge DeMango with respect to dismissing both the counterclaim and the complaint.
I'm unanimous as to dismissing the counterclaim. I'm not joining in the complaint. I'd give him 15.
Okay, very good.
This courtroom is again in session.
Well, gentlemen, this is a very interesting case. Quite a different topic here for what we generally listen to, but we listened very, very carefully to your testimony. We reviewed all of your evidence. We looked in depth at the contract. So, we're going to start first with the counterclaim because on that issue we are unanimous. Mr. Urizandi, we are going to dismiss your counterclaim based on several reasons, but primarily because we believe that this matter was previously adjudicated in another forum of competent jurisdiction that resolved this case on the merits unfavorable to you. We are going to follow that decision based on the testimony. And so for those reasons, your counterclaim is dismissed. All three of us agree. Mr. Scott, as to your main complaint, we are a divided court. Judge Acker has dissented from the majority opinion here. She feels that you are entitled to a return of the $1,500 that you turned over to the defendant. So in total, you would have kept $3,000 for this. Judge Corriero and I feel that you could not show us and that you did not, based on your own testimony, present him with a petition that had any signatures that you yourself or your people personally signed. And as to the other signatures that you say you became aware of in his proceeding in the other courthouse, that there were 3,000 in total, we had no way of knowing. He had other people also collecting signatures. So we have no way of knowing what signatures were attributable to you. So therefore, you failed to meet your burden. But in any event, by proof of the contract, even if you got 0 signatures, you were entitled to keep $1,500, which you did. And as I said, Judge Acker would have given you the balance back on your $3,000. We, sir, are not willing to do that. And so the majority is to dismiss your complaint as well. So the bottom line here is neither of you have prevailed in this matter, and you have all 3 of our signatures. And so this case is resolved unfavorably to both of you. No more bringing causes of action on this particular set of facts. Case dismissed.